PIA and AAI for having this very important panel. I'd also like to thank Chairman Ramirez for your leadership on this issue. I agree with you that this is not a broad brush solution. It's not a one-size-fits-all. But I'd like to confirm a lot of your remarks in terms of the importance of a 6B study as well as the importance of antitrust law. So most of my 7 to 10 minutes will deal with antitrust law, but let me just pause at the outset to talk about exactly why a 6B study is so important. A 6B study is so important because transparency is a vital issue here. So much of the PAE model is based on secrecy and shell games and subsidiaries and not knowing who you are dealing with. A lot of folks have talked about fixing this. The President, Congress, all have different ideas for fixing it. But nobody has the 6B subpoena power that the Federal Trade Commission has. This is an absolutely crucial power. It distinguishes the FTC from the DOJ and everyone else around here. So if we really want to get to the bottom of what's going on here, I would wholly advocate a 6B approach. And if there were any doubt as to how effective this could be, let's go back to the last one, the generic drug study in 2002. At the time, there was a thought that maybe there were some shenanigans going on in the pharmaceutical industry, but we didn't really know. And so as a result of this study, we found out that brand firms get multiple 30-month stays, each time keeping the generic off the market. So that was changed, so now you only get one 30-month stay, and all agreements had to be reported to the agencies. As a result, we know what agreements are being engaged in, and even though it took 11 years, the Supreme Court this week showed that there really is a problem with these agreements, that they can be anti-competitive when brands pay generics to delay entering the market, they can be unjustified, and they hurt consumers. And so if you trace that back to the 6B study 11 years ago, you can see how these studies play such a crucial role. Let me focus most of my attention this morning on, or this afternoon, on antitrust. Now, I agree that there is a lot else going on in this space. You have President Obama and Congress talking about so many things that can be done at every stage of the litigation process, beginning from the beginning with transparency, moving on to demand letters, suits against customers, going to litigation in terms of attorneys' fees and the International Trade Commission, and so many other things. And there is a role for each one of these types of activities because each one deals with a problem. Now, again, just to be clear, just because you are a PAE, however defined, that doesn't mean that you do something wrong, or that doesn't mean that you violate the antitrust laws. But it does provide some indication in many cases that there could be some problems here. And so even though there is a role for each of these entities to play, what I would say above all else today in this setting looking at the antitrust laws is that antitrust law has a role to play as well. And even if there were a 6B study and that took some time to develop, even before that result came in, and even if all the empirical evidence is not yet collected, there still can be an antitrust action brought when there is behavior that violates the antitrust laws. And so again, it doesn't matter that some PAE might point to some inventor somewhere that has benefited through the PAE model. If there is another PAE that pairs up with an operating company and does what the operating company can't do on its own, that could present the anti-competitive harm that could lead to an antitrust violation. So let me point out 3 potential antitrust causes of action that the agencies could focus on. First is Section 7 of the Clayton Act, second is Section 2 of the Sherman Act, and third is Section 5 of the FTC Act. In terms of Section 7 of the Clayton Act, that focuses on an ability and incentive to harm competition. As a result of a merger or acquisition, does this new entity have an incentive or ability to harm competition in a way that it did not before? This is just hornbook law of what the agencies have done. There's a handout in which I list a whole bunch of these. If you want one example, think of the Microsoft transaction in 2011, getting the Novell patents. When Microsoft owns the Novell patents, they would use it differently than when Novell owns these open source patents. And so that was part of the transaction by which it could go through, that Microsoft had to do certain things, like make sure that these patents stayed open source. Ability and incentive would differ depending on the identity of the owner. That is key here. to understanding why PAEs are so concerning, because PAEs have a different ability and incentive to exercise competitive harm. There is no risk symmetry here. It's all the risk is on one side. So for example, you look at operating companies. The two companies are in a phase of mutually assured destruction. Imagine you have, for example, Apple and Samsung, and Apple says, Samsung, you're infringing my patent, say a slide to unlock patent. And then Samsung could go back and say, well, actually, you're infringing one of our wireless patents we've had since the 1990s. The fact that Samsung could come back and challenge Apple might lead Apple to think twice about filing a lawsuit. That is mutually assured destruction. That is risk symmetry, and that is the benefit when you have two operating companies suing each other. And the smartphone patent wars perhaps are one exception here, but notice that this dynamic is absent when we talk about PAEs. They do not have any skin in the game. They don't have anything to worry about in terms of being sued because they make no products. So they can file lawsuits without worrying about being sued back. They don't have to worry about effects on shareholders, on employees, on people spending time in depositions, because litigation is their business model in so many cases. And so one of the real main points here is that the ability and incentives might be different when we talk about PAEs. Now, how does this present an antitrust problem? When the PAE gets together with an operating company, you see that there is harm that the operating company cannot do on its own. So, for example, you look at one transaction that's gotten a lot of attention between Mosaid, Microsoft, and Nokia. So Mosaid gets the patents from Microsoft and Nokia. It gets a lot of patents, 2,000 patents, including 1,200 wireless patents. It pays less than $20,000 for them, which is a pretty good deal, but somehow they expect to make $500 billion in the next 5 years and maybe $1 trillion overall. So that's some money, and it has to come from somewhere. And so basically the question is, where is it going to come from? Well, it's going to come from lawsuits, from demands, from demand letters, and from lawsuits. And when you look at the transaction itself, there are minimum royalty milestones, which means that Mosaid has to sue a certain number of people, or at least make a certain amount of money. Otherwise, Microsoft and Nokia can pull back the patents. And so there is an incentive for Mosaid to use these patents in order to get as much money as they possibly can. Further showing the potentially adverse effect is that Microsoft says, hey, you can't go after any third parties that use Microsoft software, Windows for mobile media. And so right there, you have Microsoft and Nokia using a PAE Mosaid to do what it couldn't do on its own. So again, Microsoft would think twice about suing users of Android, but now that it goes to Mosaid, Mosaid can go directly to Apple and other companies, not worried about the countersuit. And so that's just one example of how ability and incentive is different in this space. And the concern is when the PAE's ability and incentive is combined with an operating company that wants to harm a rival in a way in which it could not do it on its own, that's a real concern and can present a challenge under Section 7 of the Clayton Act. The second potential action is Section 2 of the Sherman Act. And so for Section 2, usually we look at monopoly power, or always we look at monopoly power. We're not talking about goods markets here. We don't have products on the market, but we have technology markets. And the agencies tell us that technology markets are markets that we can look at where we have a market for a patent or its close substitutes. That's what we're talking about here. Intellectual Ventures tells us that they have invention markets. And so certainly we can have market power in a particular opportunity. And then the question is, well, what's going on? And there are two things to look at in particular here. So the first is the standard setting context that Bert talked about. The concern with standard setting is that a patentee gets more power as a result of its patent being incorporated into the standard. So ex ante, when there are a whole bunch of patentees that are potentially having their patents incorporated into the standard, we don't worry so much. Ex post, after the industry is locked in, we worry a lot more. one of the tools by which we control that is a RAND term. RAND is reasonable and non-discriminatory. In Europe, it's FRAND, fair, reasonable, and non-discriminatory. And the point is that the patentee makes a promise ahead of time when it doesn't know if its patent is going to be incorporated into the standard to say that it promises to reasonably license the patent. And so what happens when that RAND promise is essential for the patentee getting its patent incorporated into the standard, but then the patentee transfers the patent to someone else, and that third party says, oh, no, that doesn't apply to us? What happens then is a complete subversion of the process. And if you think that this is hypothetical, just think of the Rockstar situation that the DOJ signed off on in 2012, where Apple, Microsoft, and Google made promises to the DOJ that we will not seek an injunction, we will abide by RAND terms. And then Rockstar says, you know what, we got these patents, and that term does not apply to us. We are separate, and this does not apply to us. If it were that easy to avoid a RAND obligation simply by transfer, then there would be nothing left of RAND at all. Another example is royalty stacking. So in addition to the patentee saying, I promise to reasonably license my patents, it might also say, here is the most that I'm going to charge for all of my patents. And so, for example, Nokia said that 2% was the most it would charge for its patents. The difficulty with PAEs is that this process can now be expanded beyond that 2%. So imagine that Nokia transfers some of its patents to Mossad, and they each charge 2%. Well, I've got a couple kids in second and fourth grade. They like math, but you don't have to be in second or fourth grade to know that 2 plus 2 is more than 2. And so the problem here is that everyone is charging 2%. You're allowed to do that, but the more companies that are adding 2% on top, the more we're going beyond the royalty stack of 2%. And then finally, I would urge some attention to FTC Section 5. This is something that, of course, is always talked about. Commissioner Wright just gave a speech a couple days ago in which he said, here's a framework that we could look at. And whatever framework you have, you need to look at anti-competitive effects and whether or not there are efficiencies. And in this case, there seem to be plenty of anti-competitive effects. What will be easier for the Federal Trade Commission is that we don't have to decide once and for all across all PAEs if the apples of pro-competitive effects weigh against the oranges of anti-competitive effects. We just have to look in a particular case and see that there is harm to consumers, that there is, for example, a breach of the RAND obligation or the royalty stacking, or products are being pulled off shelves. We see anti-competitive effects there. And then we might also see that there are no good efficiency justifications for the activity. So, for example, if the PAE cannot, as a result of a hypothetical 6B study, cannot point to any benefits other than maybe one inventor that said, I benefit from this process, then you can see that there are real questions about efficiencies. In addition, you look at other indicators like when in the patent term this thing is used, you look at secrecy, and you see that altogether there could be a potential claim here where there's a lot of consumer harm, where there is not a lot in the way of efficiencies, where you have causation, where you have a technology market. This is the type of frontier activity that provides a strong Section 5 case, and this is something that the Federal Trade Commission can do. So in conclusion, I am a strong supporter of a 6B study because there is so much here that is hidden in shell games that cannot be uncovered otherwise. And I also am a strong supporter of antitrust in the appropriate circumstance where there is anti-competitive harm and where there is not a pro-competitive justification. I think antitrust has a crucial role to play. Thank you.
But everybody can obviously jump in. In terms of FTC Section 5 authority, what are some of the benefits but also drawbacks of using Section 5 in this area?
Well, with Section 5 in general, the benefits are that it can reach whatever you want it to reach.
Madam Chairman, you got a license.
That's Josh, right?
So, So, of course, not everyone agrees with that. And the Section 5 is an open book, and we don't know exactly what it means. We do know that it covers activity that goes beyond just the antitrust laws. And so if you want to target this activity, then maybe Section 5 is a good way to do it. Again, some folks say, well, that's the problem with Section 5. What sort of guidance do you give to the business community if you don't have a definite framework for what it does mean? But I do think that one of the theories that has been offered for Section 5 is this frontier or incipiency type of analysis, in that courts have not yet dealt with this. It's not something for which you have 100 years of Sherman Act case law, and so therefore perhaps we could stretch the bounds a bit. And I think the reason why this might be a good place for Section 5 in an appropriate case is because it does have, even with what Commissioner Wright just said, it does present in certain cases a lot of anti-competitive harm when you think of companies pulling products off the market, raising rivals' costs, maybe increased price, reduce innovation. These are significant anti-competitive effects, and in many cases, my guess, a 6B study could show this even more, my guess is that there are not a lot of efficiencies. And so in some of the cases, if not a lot is making it back to the inventor, but there's a lot of anti-competitive harm, and you can't rely on a stable of strong antitrust case law, maybe Section 5 is a possibility.